Welcome everybody to today's presentation, the 14th Amendment, Birthright Citizenship and Equal Protection of the Laws. I'm Magistrate Judge Gabriel Fuentes, and I'm pleased to introduce our panelists today. Kate Mazur is the Board of Visitors Professor of History at Northwestern University. She's a widely recognized expert on the Reconstruction era. Her most recent book is Untitled Justice Be Done, which is also titled America's First Civil Rights Movement from Revolution to Reconstruction, published by Norton in 2021, will be out in paperback in June. Just this past week, Until Justice Be Done was named a Pulitzer Prize finalist, a special honor for which we are pleased to congratulate Kate today. The book inspired this webinar as an exploration of how the 14th Amendment evolved in the half century before the Civil War, from a broad movement toward racial equality in America. Birthright citizenship was a part of that, but so was the 14th Amendment's requirement that states not deny equal protection of the laws to all persons, that is, persons within their jurisdiction. With us to talk about the 14th Amendment, some of the parallels we might draw to today's civil rights context, is Griselda Vega-Samuel. Ms. Vega-Samuel is the Regional Counsel for the Midwest Office of the Mexican-American Legal Defense and Educational Fund, one of the most venerable civil rights organizations in America. As the Regional Counsel, she works to protect the civil rights of the Latino community in areas that include employment, education, voting rights, and immigrant rights. This is through litigation and policy advocacy. She's an attorney with more than 20 years of experience, and her policy work has included the protection of migrant labor rights in the United States and Mexican legal frameworks. Before joining MALDEF, she was the Senior Director of the Anti-Trafficking Program at Safe Horizon in Brooklyn, New York. So before we start, I'll let everyone know a couple of things. We will have time for questions at the close of our presentation, but we encourage you to submit your questions as we go along. We'll be looking at them, may address them during our discussion. Also, 1 hour of continuing legal education is available for our lawyer participants, and at the close of the program, I will give you that CLE code. We've included several written materials for your review and reading pleasure. You will have to download those during the webinar if you want to review them, because they will become unavailable after the webinar concludes. So finally, we want to invite anyone from our lawyer community who's not currently a member of the Federal Bar Association Chicago Chapter to join us. This is one of the quality continuing legal education programs our organization regularly puts on. And to join, you can go to our website. It's www.fedbarchicago.org/membership. So with that, I'd like to begin, and maybe what we'll do is just turn to you, Professor Mazur, and ask you, your book details how the nation's first civil rights movement evolved before the war. Can you tell us about how the resistance to discriminatory and racist laws aimed at freed slaves gained momentum by the time of the Civil War and afterward, resulting in the 14th Amendment's enactment?
Thank you so much. It's great to be here, and thank you, Judge Fuentes, for bringing us together. So to jump right in my book, I talk about the kind of decades of struggle, particularly in the free states, that paved the way and kind of laid the groundwork for the 14th Amendment. So if many people who know a little bit about history, or maybe even a lot, will imagine or think that the 14th Amendment, which was passed by Congress in 1866 and ratified in 1868, came out of the immediate moment of 1865, the end of the Civil War. Congress looked at what Southern states were doing in terms of passing black codes and things like that, and decided they needed to intervene right away. And thus came the Civil Rights Act of 1866 and the 14th Amendment, kind of in direct response to what was going on in the South in 1865. And in my book, I write about how, while that is kind of immediately true, there's a much longer history to the ideas contained in the 14th Amendment. And so to just give a really quick gloss on that, and we can go into more detail if we want or we have time, there's two main axes that I talk about in my book. One is state level and one is interstate level. On the state level, a lot of free states had explicitly anti-Black, explicitly racist laws, including the state of Illinois. these laws said things like, they use the terminology, no Negro or mulatto shall, or Negroes and mulattoes have to register for when they move into the state, when they move into a jurisdiction. People of African descent were not allowed to testify in court cases involving whites. Public education was reserved for white students only, and Black men were denied the vote. And so there were these laws that applied only to people of African descent that did not apply at all to white people. And in the book, I talk about the fight to repeal those laws at the state level. So there was, from the time that the Constitution was originally adopted until the 14th Amendment was ratified, there was, most people considered that explicitly racist laws like those laws were entirely constitutional and under the federal Constitution. And so these struggles had to be at the state level. You had to get the Illinois legislature or the Ohio legislature to repeal the laws. There was no recourse to federal authority. So in the book, I talk about the movement that kind of comes together, led primarily at first by free African Americans, but which many white people gradually signed on to get these laws repealed. On the interstate side of things, particularly on the East Coast, where there were a lot of free Black sailors who worked in the trade that went between the northern cities like Boston and New York and southern ports like Charleston and New Orleans, southern states passed laws that required free Black sailors to spend time in jail when their ships were in port. And I write about how as Black sailors came back and reported on how they had been incarcerated, and how when they were in these prisons, they encountered other free Black sailors from the North who were threatened with sale into permanent bondage if nobody got them out of these jails. As people kind of talked about those experiences, a northeastern movement mobilized to not only try to get the Massachusetts or the New York legislature to try to do something about this, which of course they couldn't really do much about what the state of South Carolina was doing, for example, but also to appeal to Congress and the federal courts to try to either get Congress to pass legislation enforcing the Privileges and Immunities Clause, Article 4, Section 2 of the Constitution, or to try to go to federal court and argue that these Southern laws that restricted the liberty of free Black sailors were unconstitutional. That also did not work. And it allowed people to come to understand why it would be, both of these kinds of struggles, both at the state level and the interstate questions, are what allowed people to come to understand that there needed to be a more affirmative federal power to enforce individual rights over and above whatever the states may be doing. And that is what laid the groundwork for the Reconstruction Amendments, including the 14th Amendment.
So I want to keep in mind what you were saying about having to have an affirmative federal power as sort of a federal floor, if you will, for civil rights. And we're not done talking about the historical aspects. But Griselda, let me ask you something. Professor Mazur was just talking about these anti-discrimination, these discriminatory racist laws, some of which in her book involved having persons post bonds to be in a particular jurisdiction because essentially there was a concern that they could be a public charge. There seems to be an effort that was directed at people's poverty as well. So do you see any parallels between that and what you may view today from your perspective as a civil rights attorney?
Sure. I mean, I see a lot of parallels. I mean, just in the last 8 to 10 years, there's really been this backlash against immigrants and attacks that are attempting to deter this sort of idea of unauthorized immigration, which is typically people of color and people who end up, who are usually in, have some kind of level of or under the federal poverty line. And so this idea that, the immigrants have to pass this wealth test to sort of participate and be part of our society really goes against the values and the core of what our country was built on. I mean, our country has been built on immigrants. And so to have this concept that now, 200 plus years forward, we're having to have people pass these tests to be part of our society is in my mind sort of just this sort of, again, this backlash. And in sort of my understanding, really this is stemming not necessarily from this idea to keep our borders, tighter and to safer, really, I think from my perspective, this really stems from this opposition to a demographic change that's happening in the country. In particular is the rise in the number of Latinos in the United States. They are becoming the largest, we are the largest minority in the United States. With the 2020 census that just came out, I mean, Latinos are now 19% of the total population that account for 51% of the growth in the United States in the last 10 years. I mean, that's enormous. And I think more importantly, contrary to popular assumption that, 44% of that Latino growth is actually growth in citizen voting age population, which means these are all children or people who have born here, and as the 14th Amendment very clearly states, are citizens of the United States. And so these changes are sort of perceived to be a threat to the privilege of those that currently hold power and who haven't necessarily garnered the support of these vulnerable groups, which are typically minorities and, in particular, the Latino community. And so, I think this idea of, the attacks or having to have this idea of you've got to basically pay your way to get into this country, I think also sort of strikes at this idea that, at least in my experience, most of the undocumented workers, which has been primarily the people that I have represented, almost never take advantage of those benefits, if you will. They are afraid, so they won't get necessarily, and they have US citizen children, but they would rather not take their child to the emergency room for fear of what that retaliation will come back, or that in fact the police will show up. I mean, I've represented domestic violence survivors who in New York City who were afraid to show up at the courthouse because ICE showed up several times. And so is that really sort of the values that we are, that our country was founded on? I don't think so. And that's why the 14th Amendment is so important, because it is fighting against these discriminatory practices, which is what Professor Mazur was discussing, right? It's like having a federal law at the national level that's going to sort of set the standard for protecting people, all people, I think is really critical. And so for us, it is something we use every day in our practice, and I have been using in my 20 plus years of practice.
So we're definitely going to explore that some more. Griselda, another question for you is, has Maldev seen citizens of the United States being targeted by what Maldev has called discriminatory laws that are aimed at the citizens' immigrant parentage? For instance, school tuition, in-state school tuition in some states.
Of course. I mean, we just fought we had just had a case in Alabama, right? Where Alabama, the state of Alabama, was hoping to, or didn't want to give in-state tuition, in fact, right, to DACA students. Or we also sued the state of Alabama when they were trying to keep undocumented individuals from being counted as part of the census. There's been this shift to try to, address this idea of birthright citizenship, right? There's been legislation introduced at various state levels and in the federal government where they want to get rid of this idea of that if you were born here, you have to undocumented parents, that you would no longer be a US citizen. And so, those are the challenges we fight every day. But, even just our basic right to vote is under attack, right? As US citizen, as a US citizen, we have been seeing these voter suppression laws across the country. And so it's like, it is a constant that we're faced with. More recently, just last week, if I'm not mistaken, Governor Abbott of Texas said that he was going to challenge the long-standing Plyler v. Doe, which Maldev brought 40 years ago. It'll be our 40th anniversary this year, giving every child, including undocumented children, the right to a public education, K through 12. And he said he would challenge that. That is long-standing law, and it's codified in the federal law. that children, K through 12, all children deserve a public education. So we are definitely seeing a sort of an uptick in these attacks, and I unfortunately would say that we are going to see more of these.
So Kate, one of the things Griselda was talking about, how citizens are being treated as opposed to how non-citizens are being treated. We know that the 14th Amendment extended citizenship to persons born here. We know that the Equal Protection Guarantee extended to persons, not citizens. Can you tell us a little bit about how those two aspects evolved, how important they were? Were they deliberate?
I have a very, I don't know, I guess I would call it a very concrete understanding of this based on the historical research that I've done. I make an argument that there were kind of a couple strands of debate in the pre-Civil War years. One strand was a debate about Article 4, Section 2 of the Constitution, which we could call the Privileges and Immunities Clause, and the question of whether it applied to free African Americans, essentially. There was litigation about the meaning of that clause for people, usually white men, doing business across state lines. But the question of the extent to which states could discriminate against out-of-state African Americans because they were Black never made it into federal court because the residents of Charleston and New Orleans actually ran people from Massachusetts out of town who were there to bring a case in federal court. And to make a long story short, one strand of what people in Congress were trying to resolve in 1866 with the 14th Amendment was to affirm that, yes, the Privileges and Immunities Clause, now renamed the Privileges or Immunities in the 14th Amendment, is for all citizens, that is enforceable by Congress, and of course by the Birthright Citizenship Clause of the 14th Amendment, that anyone born in the United States is a citizen of the United States, including, of course, African Americans. But there's a separate whole discussion in this period about personhood and the rights of persons. And people in the 19th century they were not entirely consistent about how they use terms like citizens and persons and things like that. And so we have to keep in mind that this is also a period in which, elites are trying to bring clarity to terminology like citizen, person, and so on. And so the person debate is that in a lot of states, like let's say repeal of the Black laws in Ohio or Illinois, it wasn't about, sometimes people said, oh, we Black people need to be treated as citizens. But most of the time they said, look, we live here too. We're people too. We should have the same rights as any other person. Sometimes, especially in the 1850s, as there were more and more immigrants coming into the United States, African Americans would say, how come a newcomer from Ireland or Germany can go to court, can have their kids go to public school when we can't? And that was not about citizenship. That was about what rights do people have of any kind of person, citizen or not citizen. And so there's a whole strand of debate about that. And so when it comes to kind of framing out the 14th Amendment, the language of personhood is also in there in the Due Process and Equal Protection Clause. And just for, those of you who are really interested in this kind of stuff, the language in the Bill of Rights and the Fifth Amendment, which the 14th Amendment's Due Process Clause draws on, is also a language of personhood, not citizenship. And so there is a tradition in the American constitutional law that people, all people, regardless of their citizenship status, are entitled to certain kinds of rights and certain kinds of protections. And that is very clearly in the 14th Amendment as well. And it really draws on ways people talked and thought in the years leading up to the amendment.
How does that relate, Kate, to what we were talking about before, the idea that there would be a federal floor for civil rights? So I suppose if you went to one state, your rights would be protected to a similar degree as in any other state.
Right, so there were no such protections before the 14th Amendment, right? So especially for, we can say especially for African Americans in particular, free African Americans who were able to move from place to place. You could live in Massachusetts, where if you were a Black man, you could vote, you could go to court, your children could go to public school in most places. And then if you moved to Ohio, you would have to register with local officials. You couldn't testify in a court case. Your kids couldn't go to public school. And so, that kind of inconsistency not to mention, of course, if you were a free Black man from Massachusetts and you went to South Carolina, you might well get thrown in jail, right? So like that kind of inconsistency is what the Congress, led by the Republicans at the time, the Republican Party, was trying to remedy, right? They were trying to say, we don't want to have and we cannot have a country with that kind of, there needs to be a baseline. They weren't trying to get rid of any kind of state authority or all, you know, they weren't trying to kind of completely cancel or subsume the states, but they were saying there's certain things that states are just no longer going to be allowed to do. And of course, one of them in the 13th Amendment is have slavery itself, right? And then another thing is certain forms of discrimination based on race in particular, but in one of the ongoing debates, right, is how far beyond questions of race does that extend, the promises of equality, of equal protection and due process? Because of course, the language of the 14th Amendment itself doesn't say based on race, unlike the 15th Amendment. But anyway, the point is, you know, sort of what they're trying to do is establish a floor. They're in the 15th Amendment also saying in the right to vote, states can make all kinds of distinctions, but one thing they cannot do is discriminate based on race. These three amendments, there had never been any kind of federal promise of individual rights before that. This is totally changing the architecture of the Constitution, and it's changing who and what is the backstop of individual rights. And for the first time, it's promising these rights, which of course, in many instances, this country has failed to deliver, right? But there never even was the promise of them until the 1860s.
Ms. Vega-Samuel, do you see that promise being kept for your organization's clients today?
This is why I think I have a full-time job, and I'll probably have a job for a very long time to come. I mean, we are seeing what I perceive to be sort of a modern attack on some of these core values, and whether that's the birthright citizenship, you know, question, or the right to education that I just mentioned, or the right to choice over our bodies, which we have been all dealing with for the last few weeks, and just even the rise in hate crimes that we have been seeing across the country. I mean, you know, I like Professor Mazur, I think it's pretty clear what the 14th Amendment says. And we have case law and precedent that says and has defined that even further. And yet we're in 2022 fighting these fights every day. And so why is that? And is it really truly equal? And do we have equality? Because I wouldn't have a job if that was in fact the case. When, you know, I mean, just recently in the state of Illinois, we had to, we filed our Illinois redistricting case because we believe that the legislative redistricting that happened was racially gerrymandered. And the Latinos weren't going to have the ability to pick a candidate of their choice. Now, we lost on a technicality, we believe, but at the end of the day, is it equality? Because who can maintain the power? And, you know, the very same things that were happening, as very eloquently put in Professor Mazur's book, is that this idea that we should all be equal and that we should have access to power and share in the representation and be able to have a voice. And at the end of the day, when we have these modern day attacks, I think it really proves that we have a lot of work yet to do. And you know, back then it was, you know, African Americans didn't have a right to property, couldn't testify in court, as she mentioned, but that still is true to a certain extent, right? We look at who has access to the justice system, and is it truly a justice system? I mean, as lawyers, I mean, I went to law school because I believed in the judiciary in a place that was going to be objective and be able to, we have justice, access to justice. We all talk about that. But we see the courts are backed up. We see that a jury trial can be very, very tumultuous, to say the least, depending on where you are. Because is it really a jury of your peers? Again, who sits on those juries, right? And do people of color and minorities or vulnerable populations have access or are able to participate in our judiciary in the same way? Is that truly equality? And I think I sort of sense this pendulum sort of swinging to the other way, and kind of going back a little bit to some of that history, which is why I think Professor Mazar's book is so important now, because as we know, if we don't know our own history, we're doomed to repeat it. And it feels very much like that right now. And so, you know, MALDEF's cases are consistently, I mean, we're constantly fighting against discrimination. And the last thing I'll share, just recently, we passed in the state of Illinois the Immigrant Tenant Protection Act, because we wanted to fight against the idea that immigrants, whether it was true, someone's immigration status, true immigration status, or perceived immigration status, simply for asking for their leaky faucet to get fixed, landlords were calling ICE on people. And so we felt the need to pass a law that would protect people from basic, you know, your basic housing. Like living in a safe home is something we all expect to be a basic human right. And people couldn't even, you know, tell their landlord to fix something like mold or something. You know, people are living in horrific conditions out of fear. And so we had to pass this statute to be able to protect all people. And some of our clients are US citizens, and having landlords call ICE on them. Like, that is the state of our world today. So we have a lot of work to still do, and the 14th Amendment is critical in our fight every day.
So maybe when we talk about your allusion to a swinging pendulum, Kate, the pendulum you've described in the first half of the 19th century was a highly favorable one toward a federal civil rights floor, but it didn't quite work out that way in the latter half of the 19th century. One of the written materials we're submitting today is a short commentary about the Colfax, Louisiana massacre, for which individuals were prosecuted when Louisiana did not prosecute those persons for murder under state law in Louisiana. Federal civil rights law allowed their prosecution until the United States Supreme Court struck that down as unconstitutional. So can you talk a little bit about, I suppose, where things ran aground? Why did the pendulum move in the other direction? And why do we see the promise unfulfilled as early as the advent of the 20th century?
Well, it's a big question. So let me just say a couple of things about it. I mean, one thing to say here, and this gets to, you know, I suppose I love hearing Griselda talk about your work, and I wish I were doing what you do, but maybe one of the reasons I do what I do is because, you know, history is so dramatic, right? So I write about the movement to, you know, for civil rights and racial equality and civil rights as a kind of social movement that's trying to make its way into politics and make change. But in the event, right, what actually happens is there's a civil war. And it's after the Civil War, it's because of this huge break in American history that we even can have these amendments, right? And that just goes to kind of what it really actually took, right? It was partly a very organized movement that had a lot of great ideas, that played things very well strategically in a lot of cases. But it was also because there was this war and there was this huge break in American history. And at the moment of trying to kind of end the war and figure out how to get the nation on a new footing, Republicans in power took that opportunity to hammer out these new constitutional amendments, which even at the time, there were more progressive ways of doing what they did, right? So the 15th Amendment, for example, when they debated it and ended up with, you know, there can be no discrimination in the right to vote based on race, color, or previous condition. They also had discussed versions of the bill that said, and also no discrimination based on literacy, religion, sex even. And those were shot down, right? Because they wouldn't have gotten through. So it's not like people at the time were not thinking about the ways. In fact, there were some very prescient members of Congress at the time who said, oh, this is going to open the door to things like literacy tests. If we don't say you can't discriminate based on literacy, what do you think states are going to turn around and do? They're going to say, we're not doing anything about race. This is just about making sure that all our voters know how to read and write, which was and became, as many people know, a proxy for disenfranchisement based on race. So I guess part of why I'm saying this now is because what the people who wanted these amendments and made sure that they happened, they were really trying to remake the nation, and change on that scale is incredibly hard. And the fact that there was a huge backlash to it is horrible and tragic, but it's also not surprising. And we should know that, right? Living in a period of relatively reactionary politics, right? That we have seen in our history, moments of progressive change toward a more small d democratic United States, and then periods of pushback against that where gains are undermined very deliberately by people who didn't want to see those things happen in the first place. So, you know, to get to the point, right? What happens after these amendments are passed and ratified? First of all, you know, in the South, many white Southerners absolutely do not want to comply. They will not comply. And the only way to try to reinforce and protect the rights of African Americans in the South is literally to keep soldiers on the ground. And that becomes a increasingly politically untenable situation for the Republicans in the 1870s. So I always like to talk about that because, I mean, especially among lawyers, people have a tendency to go straight to the Supreme Court. Like, why did the Supreme Court fail us? And the Supreme Court failed us. In interpreting these amendments incredibly narrowly, starting, you know, most people would say with the Slaughterhouse decision in 1873 and going forward with a series of really major decisions that shrunk and shrunk and shrunk the ways that contemporaries were allowed to understand and bring cases based on these Reconstruction amendments. But let's not forget the popular violence, the popular lack of support, particularly in the South, for the amendments, right? So if people had actually accepted, you know, this country is a changed country, we're going to do things differently now, maybe even at the state level, we're going to prosecute some of these cases so as to maybe even avoid getting the federal government involved, the federal courts involved, things would have come out quite differently. And so, you know, it's a combination of different factors, including most certainly the Supreme Court, that ends up, you know, basically kind of suppressing what these amendments could have done. And it's obviously not until, you know, to some extent 1954 and Brown v. Board of Education, and then certainly the Voting Rights Act, the Civil Rights Act of 1964 and the Voting Rights Act of 65 that really put these things back on the table in a meaningful way. So, you know, it's many, many, many decades in which the 14th and 15th Amendments went largely unenforced.
I'm really glad you mentioned Brown and the Civil Rights Act because Professor Eddie Glaude has said that America didn't really become a post-racial democracy, or didn't begin to, until about 1964. So, Griselda, Kate was talking about an era of reactionary politics, today's era she's referring to. So that's what, about, you know, 60 years after passage of the Civil Rights Act. And what kind of challenges does that present for you and MALDEF, given that you're trying to use the 14th Amendment to say, no, there really is a floor. It cannot be state by state. And what kind of challenges are you looking at, particularly given challenges you may face in the current Supreme Court?
Well, I mean, it is, I think these are challenges that we're all facing across the board. I mean, I think what we're seeing coming out of you know, the U.S. Supreme Court is very much challenging sort of all civil rights attorneys across the country. You know, the way I see it, you know, our founders created the system of checks and balances, right? And we have these three distinct sort of systems, and we're all supposed to keep each other in check. And, you know, at the end of the day, you know, Professor Mays just described, right, that the Supreme Court at the onset was sort of narrowing and not enforcing the 14th and 15th Amendment, and therefore it took Congress to pass these other laws, right? And so again, it's this the importance of this checks and balances. And, you know, what we're seeing now is sort of a dysfunctional Congress that can't get anything done. And so that makes our work that much harder, because if we're seeing what's coming from the U.S. Supreme Court, and as lawyers, civil rights lawyers, we are having to be very careful about and very strategic about what we are going to do moving forward, in which cases we bring forward, because we're not sure what's going to happen down the line. But more importantly, if these types of decisions keep dwindling our rights, and we can't depend on Congress to sort of be the champion of and react and protect our rights in whatever the need is, we're going to have to be very careful because the fights are going to only increase that much further. I mean, I was on a call with a colleague this morning about voting rights in Missouri and how there's a bill in their session just today, and their session ends tomorrow, where basically it would take the power of the state, of the Illinois or of the AG's office that is, we would fight against, would be our defendant, that if there was any change to the election law, that the AG would have no right to, or no ability to negotiate, because the legislature could intervene, and therefore they could then bring in their own private attorneys to, be the people that we have to negotiate and figure this out on. And so these kinds of statutes are being introduced at the state level because, to the professor's comments, right, the states are trying to change things and are fighting back. So that makes our job that much harder, because if we bring a federal lawsuit and the people that we think we're going to fight aren't going to be the ultimate negotiators because somebody else is going to be able to intervene, all of this is going to take up significant resources. And so as civil rights nonprofit attorneys, we're going to have to be very clear about who and what fights we're going to be able to take on, and be very strategic about how many of these fights can we take on. And it goes against everything that she just discussed. I mean, this is the reason we have these federal laws, right? Is to sort of set that foundation. And here we are fighting at every state. I mean, MALDEF has lawsuits against, voting rights lawsuits across this country. And there's only so many of us, and the ACLU, our partners at the ACLU and Lawyers Committee, and there's only so much we can do. And so the last thing I guess I would say is, for me, the biggest lesson coming out of this is elections matter. And we're going to have to be informed voters about how we move forward. We have a full election cycle in front of us, and we've got to be very, we actually have to vote, and we have to encourage our communities to vote, because if we don't, what's coming down the pike is pretty scary. And I would venture to say our fights are only going to really increase. And I don't know where this, are we going to get to what, I heard the professor say civil war. Is that really where we're headed? It's unfortunate, but it is very possible. And are we ready for something like that?
What you said calls to mind a little bit of some of the things John Meacham has written, where he has said, America has had times of great division. It has always survived. He is, I think, more encouraging taking a longer view. Professor Mazur's book has described an almost generational kind of shift back and multi-generational back and forth. So Griselda, how pessimistic or optimistic are you about the long-term prospects for some of your goals?
I feel like it changes day to day. I came to the law with a very optimistic, and I've been an advocate. I've been a nonprofit lawyer for 20 years, my entire career, because I believe in the ability to depend on the judiciary and be an advocate and protect those rights that I believe are, even for those that are, letter of the law, I think are pretty clear that the 14th Amendment should protect all people. But, as I see this shift happening every day, and again, right, what happened last week with the leak of the document of that decision, really, I think, to me, challenges and really puts, I think, the legitimacy of the Supreme Court in jeopardy. And it makes me sad because, I always, SCOTUS is supposed to be the ultimate arbiter, right? The ultimate decision maker. And, to have this happen and to challenge some of our, what we believed was a pretty strong right that could have been better, because it could have been codified in federal law, and hopefully we'll get there. But ultimately, it actually makes me a little pessimistic about how things are going to transpire. I mean, I think the other piece here that I was going to mention earlier, which is social media. I mean, it has become such an integral part of our daily life. And I think part of that has also led to people making it easier for people to voice certain opinions. And that is part of the fabric of our society. And so I feel like people aren't sort of doing these discourses, which is why I definitely want to thank Judge Fuentes for bringing us together and having these discussions, because I don't think those are happening in this manner. And people are very easily sort of get on this bandwagon and hiding behind, a name or a fake name or a profile. And so if that's how people are getting their information, then we're not really getting to fact checking and being informed voters and being informed citizens and people living in this country about how we want our future and where our country should go. So as an advocate, I think it's going to get harder for us to sort of do the work that we do. And I think the last thing I'll say is, what makes me sadder is, as I mentioned earlier, I think there's going to be an increase in the number of fights. And so people like me are going to have to make choices about which case I take over what case I can't take, even though they all, have merit. And, MALDEF has to, our focus is impact litigation because of our very, minimal resources. And so we've got to pick a case that's going to have the largest impact. And so that may mean we don't take another case. And I mean, my other colleagues out there across the country are going to face the same challenge. And so that's going to be really, really hard to do. I think that's the hardest part of my job, is to have to turn people away. And I foresee that I'm going to have to turn people away in the future, because I think we're going to go through a period that's going to be pretty rough for a while.
So pessimism. Professor, I want to turn to you with the same question, keeping in mind that Griselda's an advocate, you're a historian, you have a different perspective, but maybe you have a view about what may or may not occur generationally here. And then I have a follow-up for you about the importance of facts.
Well, historians, I think, are rarely very optimistic people because, when you see the long view, I mean, one of the things that a lot of historians know is that narratives of inevitable progress are usually kind of propaganda, right? And our country, often Americans like to tell ourselves some version of a progressive narrative, and this progressive in the sense of like, this country's getting better and better, or maybe like we were on track to getting better and better until this happened or that happened, and we need to get back on that track, whatever that might be. And one thing that the history of Reconstruction really reminds us, right, is that change that, kind of pro-democratic, small d democratic change, it does not always go forward. Rights can be taken away, promises can go unfulfilled. And so, I'm not going to sit here and say that, these kind of rollbacks that we're seeing are not real. They're super real. And, obviously to people here, like, one of the problems, if you see it this way, is the structure of our government itself and the undemocratic kind of checks in the government, like the Electoral College and the Senate, that really, mean, and the Supreme Court itself, that really mean that, for instance, on the issue of reproductive freedom, right? Like, a majority of Americans, by any measure, support some version of a right to terminate a pregnancy, and yet we are being held hostage, apparently, by a court that has a minority view. A majority on the court has a view that does not represent most Americans. So things like that, or even voting rights, right? I mean, I don't think that most Americans want to see citizens' access to the right to vote diminished in the way that many state governments are now doing, and the Supreme Court seems to support. So I think, I think that the thing, there's a sort of more ethical position, and I think, I'm sure that, Griselda, you wouldn't be doing the work that you do if you didn't sort of believe on some level that that kind of work matters. And I think that from the perspective of myself as a historian, like, I also think what people do matters. And when people resist oppression, that matters. It can make a difference. The people that I write about my book, were up against a lot, and they made a dent. And one of the lessons I think in my book is about the importance of politics, that yes, voting really matters, who you vote really matters. Coalition building, that it is really important to come together with people around issues, even if you don't agree on every issue, but trying to find allies to create a more powerful coalition than you would have if you were acting alone with your whatever kind of smaller group that you're in. And I think the long game too, you know, the people that I write about were not, some saw victory, some saw certain amounts of victories in their own lifetimes. Some were paving the way for changes that they believed in that would never come during their lifetimes. So, you know, I think that stuff matters. I think it's really, as I teach college, I think, you know, it's not, and I don't mean to say this is kind of, we have to tell our students that there's something to believe in and it's a big lie. I don't think it's a lie. I think that it's really, you know, it's really true, and that, but also that we have to find ways of thinking and talking about what makes a difference at what level, lest people, especially young people, feel really demoralized at this moment.
Okay, so facts, and bear with me for musing a little bit here, but John Meacham, his conception of everything was okay in the end, in some ways is predicated on the idea that over the last 200, 250 or so years, we've had an ability to have some national consensus on facts and what they are. Griselda mentioned social media. Facts have a big impact on political discussion and debate. Birthright Citizenship, for example, I would offer for you that your book does a great deal to clarify why did it extend to persons born here, because otherwise freed African American slaves would not be citizens, and there was a clear intention to do that, a fact that seems to have gotten, I think, a little bit lost in some of the debates. So how do we fix that if we can?
I mean, you know, this is what, I don't know. I was recently writing something about the formation of the Confederacy, and the people who wanted secession were going around saying that Republicans, you know, were essentially rapists and degenerates. And I mean, they were the propaganda that white Southerners were spouting about both African Americans and white Republicans in order to promote secession was really astounding. And it was a good reminder that, like, there have been other times in American history when there are fact-free environments, right, where people are just saying stuff in order for political gain, right? So some of that is not new. But, you know, I'm out here, this is why I'm a history professor. I am trying to work with teachers. I do some stuff with K-12 educators. You know, people don't only learn history in school. They don't only learn facts in school. I mean, I feel like my go-to on this is about education at early grades, right? About teaching about how do you discern reliable sources, right? How do you decide if a source is reliable or not? How do you form opinions about the world? And they don't, obviously, I'm not saying that everyone should have the same opinion. It's not about brainwashing or anything, but it's about trying to help people become educated citizens who have facts at their disposal. But, you know, and I think obviously there's a whole other topic in, you know, the CRT panic and all the stuff that's about attacking the ways that we do education, again, at the state level. And so, you know, I think that is another battleground. And I also think that schools are only one piece of the puzzle. So I think it's a huge task. And, you know, I think, you know, one of the lessons to me is if we're interested in this kind of thing, people have to find a way to address it that's at a level that we can do, at a place that we have the skills and the kind of ability to do it.
Griselda, what, if anything, would you add to that?
I mean, as lawyers, right, facts are critical. It's our case. Our cases are built on facts. And I think the one thing I would say is what I've seen, and, you know, I grew up in the generation where when I did my research, I went to an actual book, which I still love to do, and like picked up the encyclopedia, and that was sort of, you know, the way we got our information. And I think the fact that we have so much information overload is almost like it's a blessing and a curse, right? Because while we have so much more access to information, it's become much harder to sort of sift through what is propaganda or what is facts or what aren't facts. And I think that's what's become harder, is that, and that's why I think also people have sort of gotten in corners and sort of decide to stay there, right? Because we are now part of our moving forward in progress is that we get these algorithms that if you click on this one thing, it's just going to keep giving you the same information over or similar information. So it's going to take, like the professor just said, right, really to get to a place where we understand that we can't depend on that one thing that keeps popping up, but that we have to go outside of, sometimes in very uncomfortable zones, and find information that we may not appreciate, but that is going to make us better, you know, citizens of this country, in the sense of being able to better engage and be civically engaged, which is, I think, a whole other topic that I know we haven't touched upon, but I think that's the other piece. Because like I grew up, and obviously daughter of immigrant parents, when they got their first chance to go vote, it was such a huge deal. It was so exciting. And seeing their excitement led to us being able to understand that voting was such an important part of our civic engagement and being part of our community. And I feel like we're starting to sort of lose some of that, because it's so easy to get on Twitter or Instagram or wherever and just see that 140-second headline and make a decision based on that. And it's like, is that really, are those facts? Is that how you're going to base your entire opinion on, you know, a headline? Like, I feel like that's where we've gotten to. And so I feel like the work that professors and educators are doing for our, you know, our future generations is so critical. But as the Professor Mazur also said, we're under attack there, right? What are we educating our children about? And so it's like, where are the facts? And I think to whoever, it depends on who you ask, because I mean, I just see it as this very malleable sort of source. I can't even like really describe it, right? Because I can, you know, when we look at cases, we look at what we believe to understand what facts are. But again, at the end of the day, right, we're advocates, and the facts that I present, my opposing counsel is going to take a very different stance on that, right? But that's our job. That's what we do. And so ultimately, facts are sort of shift changing. And so I think the last thing I'll say is, I've said it earlier, we have got to be able to become better informed, and we have to sort of make ourselves sometimes very uncomfortable by seeking out facts that we may think aren't facts, but in fact is going to help us become and form a much more, a better and a more informed opinion. So then we can really make some really tough decisions. Because I think that's the other thing that's about to happen, is we're going to have to make some tough decisions moving forward. And so it behooves us all to really get out there and educate ourselves about a variety of different things and getting them from a variety of sources.
Okay. Well, gosh, I think we'd like to leave some time for questions if we have any from our distinguished audience members. Perhaps because I'm technically challenged, I haven't seen any yet. So if you do have questions, now would be a good time to fire away. And in the meantime, I will ask, I'll ask you, Professor Mazur, the project that you did in Until Justice Be Done, is it leading to other projects that are coming down the pike for you? Or what's next after your treatment of what happened in the 19th century?
Good question. I see a question in the chat that Lisa Jackson posted.
Fire away.
So the question is, was the term person not deliberately chosen because of the fact that African Americans were not recognized as citizens until the 14th Amendment was ratified? And is not the concept of person in antebellum thinking susceptible to the general statements because of the variety of opinions on whether African Americans were persons to begin with? And then Abraham Lincoln was inconsistent, and David Potter's book, The Impending Crisis. You know, so I'll just like I'll just say something about this quickly. So I don't think the framing, no, I would disagree with that, because the 14th Amendment the first part of Section 1 says that all persons born in the United States are citizens of the United States. So if the personhood language was only in there because African Americans were not considered citizens until let's say until the 14th Amendment was ratified, by definition, once it's ratified, you don't need the personhood language if you think that because they're citizens now, right? So like, why would you, if it's only about rights for citizens and you're making African Americans born in the United States citizens of the United States in the amendment, then that wouldn't make sense. You wouldn't need to have it there. So I think it was, as I said, because there was a very wide-ranging discussion of the rights of personhood before the 14th Amendment. This was a country that was receiving a huge number of immigrants by the 1850s, the most problematic of whom for a lot of white Americans were Chinese immigrants. So there's also a very big kind of discussion and a sort of bifurcation in how people talk about what's going to happen with immigrants from Europe versus these major who presumably, according to most white Americans at the time, are desirable and going to assimilate. Well, some white Americans think that, as compared to Chinese immigrants who even Republicans who favor the abolition of slavery wanted African Americans to have civil rights. Many Republicans also had a big problem with the idea that Chinese people would vote or become citizens. And so it's actually all the more significant that they put birthright citizenship in there, knowing about and knowing kind of the subset of Republicans who had a problem with the idea of Chinese citizenship, because they made it so that the children of Chinese immigrants also were citizens, a point that was reinforced in, I think, the Wong Kim Ark decision. Anyway, that was a little bit of a digression, but it is very clear that Americans are having a conversation not only about what citizenship entails and who is a citizen, but also about the rights of personhood. And those two things, which are separate discussions, are folded into Section 1 of the 14th Amendment. And I make a very explicit kind of argument with that, documented by sources in Chapter 9 of my book, which you have access to. It's part of the materials that we're distributing here.
So if you want to download those materials, we're almost at the end of our session, so please download them now, since the technology doesn't let you do that later. You mentioned Chinese Americans or Chinese immigrants, Ms. Mazur, and I'll just ask you, the level of racism and discriminatory laws directed at Chinese immigrants in the 19th century, an often unreported, undiscussed aspect of American history. Well, can you explain a little bit how that's going on at about the same time we have a broad Republican coalition in favor of rolling back anti-Black statutes?
Right. So, the Republicans, and the Republicans of this era are really interesting. These are the people who fight the Civil War, who engineer Reconstruction policies, the Reconstruction amendments. They were also, another thing about them is they were also all about taking land from Native Americans. They fought those wars against Native people to dispossess them so that, white folks could settle in the lands that Native Americans were on. And some of them, but not all of them, also were really worried about Chinese immigration. And particularly in the 1870s and 1880s, some Republicans from the West, particularly from California and Oregon, were swayed by kind of popular politics out there to turn to sort of say, yes, Black citizenship is okay, but we need to stop Chinese immigration. And I don't want to open us into a whole new thing, but in the period before the Civil War, immigration was actually mostly a state level policy. So part of what I'm talking about in the Black codes of places like Illinois and Ohio, these are essentially state level immigration policies designed to discourage immigration into the state by free African Americans. And what happens after the Civil War is that is when the federal government takes charge of immigration policy for the first time and kind of asserts the federal prerogative over immigration. And why do they do it? And kind of what is the impetus for doing it? It is the perceived threat of Chinese immigration. So the first federal immigration laws of any significance are passed directly in relation to regulating and then trying to exclude Chinese immigrants. So it's a very, very significant part of American history, both in terms of the history of immigration and also the history of federal policymaking.
So we've already talked a little bit about the elephants in the room. I don't know that we need to go more on that, but I will just ask you one thing, Griselda, as we close. We sometimes see in Supreme Court decisions, other decisions, reference to being guided by history and tradition. And I just ask you to look a little bit at what you might view that history to be when we have Chinese exclusion, efforts through the Black Codes to, in effect, render freed enslaved people slaves again. You know, how much of this, and now the public charge matter that we discussed at the beginning, how much of our social movements as they relate to race, how much are they driven by economics, the generation or the transfer of wealth and economic interests?
Well, I mean, I actually think that the economic interest has always been at the core of all of this. I mean, Professor Mazur just described, right? On one hand, we're trying to, you know, facilitate the African Americans who have just been freed and giving them equal rights. By the same token, we are excluding Chinese American or the Chinese immigrants and putting them in camps, right? Like, and taking land from the Native Americans, all because, again, it's about, I have to get mine, right? Like, I mean, let's face it. I know in our planning conversations, the way although, you know, I've been doing this for the last 20 years, I feel like it always happens that someone's got to be at the bottom of the totem pole, right? It's like as people sort of progress up, I mean, we were based on immigrants, right? We had the European immigration that basically built, you know, helped start building the East Coast. And then came the next wave. All of those people moved up, and then the next wave came, right? I've been representing farm workers for so many years, and they are at the core of putting the food on our table. And yet, you know, all of these, you know, proxies, like we were talking about, the public charge, this idea that you have to pass this wealth test to get in, is really just race discrimination at the core. And whether it's English only laws that are starting, you know, that are out there, or, you know, like I said, perceived immigration status, like these state laws that are getting passed with these, you know, as proxies, ultimately is to discriminate against the people that are behind us. And so it's, you know, and it's all because I'm getting mine, and so I want to move ahead, but someone's always got to be sort of doing the grunt work or doing, or you know, not getting theirs. And so at the end of the day, it's all about economics. And you know, I also mentioned earlier that Latinos becoming the largest minority, right? We are part of this massive growth, and to the extent that we are now going to be part of a society that we're going to want to share in some of that power, again, is what is causing some of this fear and causing some of these discriminatory practice because of these perceived notions that all Latinos are immigrants or and illegal. I hate that term. But you know, we want to keep people out. We want to tighten borders. We want to keep, you know, America great and safe. And it's like, but really, what's the impetus? The impetus is we want to keep other people out so that we keep the power in a very like discrete, you know, core of group. So, you know, at the end of the day, you know, of course it's about economics, and it's like, it's about the haves and have-nots. And unfortunately, I think we also know that that wealth gap is increasingly getting wider and wider. We're losing the middle class altogether. And is that really what, you know, I mean, pictures of the 1950s of middle America with the house and the white picket fence and the dog, right? That was the American dream. And we know now that most people can't even buy a house right now. So again, I feel like there's this shift. And so, you know, the future is I think we're doomed to be repeating some of the things that are in Professor Mazur's book. And so I definitely encourage everyone to get the book, because it's a great book, and it's just a really great account of where we've been and where we may be headed.
So Kate, there's an old saying about being doomed to repeat history. You want to remind us what that is?
No.
But I won't
No.
ask you to. But go ahead, I'm sorry.
No, well, I mean, what is it? I mean, it's sort of like if we don't know our history, we're doomed to repeat it.
Yeah, I was going to refer to those not reading their history being doomed to repeat it.
Yeah.
The other thing that Griselda said that rang a bell with me was, the part about people wanting to get theirs. So, I mean, the history of Chicago, big American city, the motto, herbs in orto, maybe a city in a garden. Maybe you remember Mike Royko's version of that motto, ubi est mea, where's mine? So what's your reaction to that as a driver of what you've seen in the study you've done of 14th Amendment and civil rights development? How much of it is where's mine?
I made a joke about being doomed to repeat our history because historians have like an ambivalent relationship to that. We need to know history. So I like that phrase because it suggests that we need to know history and you can learn from history. And there are things we can learn from history that we can use to inform our present day decisions. Whether we're going to repeat our history, I mean, I think things don't really repeat because we're always at a different moment, right? And if we're talking about greed and kind of getting people, I want mine and I don't care, I'm going to pull up the ladder before anybody else comes up, like, we're at a different stage of capitalism, for example, than we were in the 19th century, right? So things look different. Things don't unfold the same way, as we're not repeating, but there's context and there's kind of patterns, right? So for example, like we were talking about this when we were sort of chatting beforehand, like part of my book, I write about how the anti-Black laws of the Midwest were built on top of the English poor law tradition. They were basically kind of a racialized variation of poor laws that British colonists brought to North America from England, and a predisposition in the history of England and English law to be suspicious of newcomers to your community and to have that communities had the right to, that basically poor itinerant people did not have the same rights to kind of reside in a place as regular old free people, and that town authorities could throw out itinerant people who were poor and kind of evict them and toss them back to their community of origin, and that those ideas, that the kind of American racial situation was superimposed on those already existing ideas about poverty and the undesirability of poor people to communities. So yeah, I mean, I think one of the things, just on a really basic level, like one of the things that the state, right, that governments are able to do is to regulate everybody's tendency to want to get theirs, right? And like reduce wealth inequality, make people pay taxes, have laws that protect people who are poor, who are not otherwise able to kind of get things that they need in life, like food, like shelter, right? So of course, like there's a tendency for people, probably all of humanity, to be kind of greedy and kind of self-interested. And that's where, I mean, again, voting, the government, that's where these things come in. I mean, how much then do we call upon public figures and public entities to come in and say, like, yeah, you can have a lot of money, but like you're going to have to give some back in taxes so that we can fund things that are in the public good, right? And obviously, I mean, I think, like, or not obviously, but in my view, we have a very, very attenuated vision of the public good in this country. And so, we have a problem really wrapping our minds around the idea that people with plenty of resources should certainly be more obligated to give back, and that public entities like governments are the place to center policies that are supposed to be in the public interest. So, like, I think that is a perennial problem in the United States, and it's a problem that's exacerbated by issues of race here, right? So that, like, because we have a racially diverse country, and we always have, there has been more of a tendency, I think, to part of, there are a lot of comparative studies of welfare state development in the 20th century that compare the United States to European countries. One of the main conclusions that a lot of historians and sociologists have drawn is, we have had a really attenuated sort of welfare state, in part because people in power don't want racial minorities in particular to have resources, right? Whereas in more homogenous societies, it has been easier for countries to do more redistributive policies because they don't have the same kinds of racial inflections in their policy, in their kind of populations.
Okay, very, very, very helpful. Let me just, I guess, just say one thing, which is one of the great useful aspects of your book and other historical studies is that, you know, we're not going to solve all the problems of the world today, but history is one way of helping us think about how we might, based on where we've been before. So it's about 1:10, and I know I started talking at noon, and I don't think I went 10 minutes. My comments at the beginning don't count toward our hour, but I think we've about reached that hour. Let me just ask the two of you if you have any closing comments. Griselda, you go first.
Well, I want to, again, thank you, Judge Fuentes and Professor Mazar, for a really great and interesting conversation, because I do think that the points we've discussed are really important. And I think we know, given what's been happening over the last few months, that understanding our Constitution and what our rights are is so important. It is one of the fundamental things we do that I've always done in my work, is teaching people what their rights are. Because I would say that discrimination is the thing that I've been fighting for 20 plus years, and we're going to have to keep fighting. But I absolutely believe in our Constitution, in our case law, in our precedent, because that is what's going to, that's what makes America great. This checks and balances. I think we're maybe at a bit of a crossroads, but I am hopeful that we will get to the other side. And part of that is becoming and informing people of what their rights are, because if you don't know you have a right, then you're not going to enforce it. And so a big part of what I do every day is to make sure that all my clients, whenever they call, even if I have to turn them away, I want to make sure that they know that even though we can't take their case at this point, they do have a right, and that they have, regardless of their immigration status, which is why the 14th Amendment is so important. And so, we are here as a resource, and that we have to keep fighting, because we owe it to the future generations to keep moving forward as our ancestors did. And so, I will leave you with sort of that hopeful message that, the fight continues, but everybody has rights in this country. And I know, I'm here at MALDEF for that very reason, because we will continue to fight and make sure that all people have the right to live free of discrimination in a country that was built on those foundational elements. And so I will do my very best to keep that fight alive.
An optimistic tone. Thank you. Kate, what would you add in closing?
I want to leave it with Griselda's closing. From my perspective, I'll just come back to my own professional commitments and identity, as a history professor at Northwestern, and someone who writes about history and tries to get out there and talk about it, outside of the walls of the university as much as I can. I want people to be paying attention, right? And I want, I just maybe circling back to the question of sort of information. I think there's a lot of, in terms of the teaching of history and kind of freakouts about the teaching of history right now in connection with the 1619 Project and other things like that. I hope people will take the time to inform themselves about what is really at stake in these discussions. And I'm out here. My email address is kmasur@northwestern.edu. I'm happy to engage with these issues. And, I really think it's important right now to stand up for, getting the facts out there and not trying to silence what history educators are doing. And I personally am not at risk for that, teaching at a private university here in Illinois. But I know that in some school districts in Illinois, this is already an issue. Even if at the state level, we're not, we're not a red state. We're not going to probably have any of these laws right now, but I know that in some particular school districts, teachers and administrators are already feeling attacked scrutinized about what they're teaching. And so, you know, I hope people will really pay attention to that as well, and not panic, right? If you're inclined to sort of say, what the heck is going on here? Like, inform yourself and, you know, and kind of, and get informed before, you know, deciding that something really terrible is going on.
Thank you. A couple of closing notes. Your CLE code for today, 12225. 12225. Remember that. The book, Until Justice Be Done, available at your local online and in-person bookstore, and out in paperback in June. Thank you, Kate. Congratulations to Kate on that. And thank you, Griselda, for your wonderful insights today. I'd also like to thank our audience members who were terrific. We didn't wind up getting more questions, so nobody's questions got skipped over. We got some nice positive feedback, though, during the session. And the last thing I need to say is that I've tried not to express any opinions of mine today, but to the extent anything I've said looked like an opinion, it would have been my own and not that of the U.S. District Court. So thank you. We will adjourn. Much appreciated, everyone.
Thank you so much.
Thank you.